The work of the Women's Safety and Justice Taskforce follows on from the Honourable Dame Quentin Bryce ADCVO's landmark Not Now, Not Ever report, which led to widespread improvements in Queensland's response to domestic and family violence. 6 years on, Queensland women and children are still suffering violent deaths. Women are speaking out loudly and articulately and demanding further action. The Taskforce had to consider and report on how to best legislate against coercive control and whether a specific offence of commit domestic violence is needed. The Taskforce invited the community to make submissions. The response has been overwhelming. We've received over 700 submissions, with over 500 from members of the community sharing their lived experience of domestic and family and sexual violence. They are from all socio-economic backgrounds. While mostly from Queensland women, there are submissions from all around Australia. Many are from First Nations women, as well as women from culturally and linguistically diverse backgrounds, the aged, and those with disability, sex workers, and people who identify as LGBTIQA+. Some are from men, a reminder that, exceptionally, women can be perpetrators. The Taskforce has also held over 125 individual meetings with stakeholders, including the judiciary, legislators, police, the legal profession, policymakers, academics and service providers. We've conducted stakeholder forums in Brisbane, the Gold Coast, Townsville, Cairns, Thursday Island, Palm Island, Toowoomba and Mount Isa. We've met with dignified victim survivors and the families of victims who did not survive, right across this large and decentralised state. Many were First Nations women, some had intellectual disability, and some were refugees and immigrants. The Taskforce has heard and learned from those voices. They have not only informed, but are at the heart of the recommendations in this report to build on past efforts, embed what works, and identify further needed reform. Despite my 40 years in the criminal justice system, my Taskforce work, completely different to my past lives as barrister, judge and Royal Commissioner, has been a process of rapid and intense education. I've learnt that coercive control is a pattern of deliberate and rational behaviour designed by one person to control another person within a personal relationship. This is done by causing the victim to fear for their or someone else's safety. The misconception that only physical violence is domestic abuse is so entrenched that coercive control victims themselves often do not realise they are experiencing domestic abuse. The Taskforce has repeatedly heard that non-physical abuse is more damaging than physical violence. As one woman told us, "I was never hit, but I was tormented with comments. I started to go crazy. I lost myself. I wasn't me anymore." I expected to hear from women about their mistreatment at the hands of perpetrators, perhaps sometimes enabled by family and community members. I did not expect to hear that women perceive that perpetrators are emboldened by police, legal practitioners and judicial officers. Many feel the justice system is failing them. In large part, that is because the system has been responding to specific, usually physical acts of domestic and family violence occurring at single points in time. The justice system has not caught up with knowledge and evidence about coercive control. Many police, service providers, lawyers and courts are failing to identify it or its devastating impact on a victim's well-being and safety. The justice system's current incident-based response also means that when a woman reacts defensively in retaliation after years of abuse, she risks being misidentified as the primary perpetrator. This can happen even when the woman has sought police help. When police arrive, she may be hysterical, whereas he calmly and manipulatively points to his relatively minor injuries and the police charge her. This is a particular problem for women with disability and First Nations and culturally and linguistically diverse women. When victims of domestic violence are misidentified as the primary perpetrator, the message to victims is that they will not be believed, now or in the future. Instead of seeking help from the police who should protect them, they remain silenced and trapped in dangerous relationships. The misidentification of victims of domestic and family violence has particularly profound impacts for Aboriginal and Torres Strait Islander women. Many of the growing number of First Nations women in Queensland prisons have been charged with breaching domestic violence orders, which perhaps should never have been made. We received many submissions, reinforced in our consultations right across the state, that many police were not responding to women's complaints of domestic violence and breaches of orders, and that this was putting their safety at risk. These accounts are consistent with findings in the Domestic Violence Death Review and Advisory Board reports since 2016. Victims and those that help them told us that many police unfairly targeted Aboriginal and Torres Strait Islander peoples, and that this was a factor in their overrepresentation as offenders in the criminal justice system. We heard complaints about the way police dealt with other officers who were alleged to be perpetrating domestic violence. We also heard concerns about how police dealt with complaints of police handling domestic violence matters. In recent years, the Queensland Government has invested heavily to support QPS to better deal with domestic violence. The QPS leadership team, many individual officers, and those in the specialist domestic violence teams are working hard to keep women safe and ensure perpetrators are accountable. But for all those good intentions and good work and this significant investment of public funds, a woman seeking police help to stay safe from a perpetrator enters a raffle. She may get wonderful assistance, or she may be turned away. The widespread cultural issues within QPS disclosed in Taskforce submissions are of grave concern to the Taskforce. Police are the gatekeepers to the domestic violence protection system. A widespread failure to assist women seeking to escape domestic violence is apt to erode public confidence in the delivery of justice in Queensland. The information received in submissions and consultations have led the Taskforce, by majority with one dissent, to recommend that the Queensland Government establish an independent commission of inquiry to examine these issues within QPS. Based on the voices of victims and their lived experience, the Taskforce has recommended a raft of system reforms to ensure the future response to domestic violence is more appropriate and trauma-informed. These include better services in regional and remote areas where rates of domestic violence are highest, a plan for safer courtrooms across the state, ongoing training for lawyers, and an independent judicial commission to deal with complaints against and education of Queensland judicial officers. The Taskforce has also recommended an urgent transformational plan to address the widespread culture, values and beliefs within QPS, which are hampering efforts to achieve better outcomes for victims. If the recommended independent commission of inquiry is established, this could form a key part of the government's response to that inquiry. The report includes a human rights framework and analysis of recommendations and examines the required response to domestic and family violence through a human rights perspective. Police, service providers, victims and judicial officers told us of a cohort of serious high-risk offenders who've breached multiple domestic violence protection orders, often against multiple victims. The Taskforce has recommended improved information sharing between service agencies and across jurisdictions, including a register of high-risk offenders. The register would not be publicly accessible because of human rights concerns and to avoid giving a victim in danger a false sense of security. The Taskforce received articulate submissions opposing the criminalisation of coercive control. The commonly cited reason was unintended consequences, particularly the likely detrimental impact on First Nations peoples in the criminal justice system. But most submissions from legal stakeholders and victims supported criminalisation. Ultimately, so did the Taskforce. This report sets out a framework for that legislation and other legislative and procedural reforms to support it. Whether in favour of or against criminalisation, submissions almost universally called for intense education right across the community about coercive control and healthy relationships. The report contains recommendations as to how to achieve this, with a special emphasis on children and young people, the aged and people with disability, and First Nations and culturally and linguistically diverse people. It is critical that education in First Nations communities should be community-led and delivered. The recommended offence will have a maximum penalty of 14 years imprisonment. There is a defence if the defendant's conduct was reasonable in the circumstances. To avoid the feared consequences from criminalising coercive control, the Taskforce has made 3 key recommendations. The first is that, as in Scotland, after any offence is enacted, there be a lengthy period before it comes into force, to ensure the community, police, the criminal justice system and the service sector are fully educated and prepared. The second is a recommended review after 5 years to ensure the legislation is operating as intended. The third is that the Queensland Government work with First Nations people to urgently develop a strategy to meet its Closing the Gap justice targets, which include reducing the representation of First Nations people as offenders in the criminal justice system. Another common submission from victims was the need for more perpetrator programs for both those in custody and in the community, and delivered at a much earlier stage. So many victims told us they did not want the perpetrators to go to jail, they just wanted the violence to stop. The Taskforce has listened and made a range of recommendations, including for a diversionary scheme for first-time offenders and an expanded statewide network of perpetrator programs. Other Taskforce recommendations include a 4-phase implementation plan for all recommendations from 2022 to 24 and beyond, an investment plan, a peak industry body for specialist domestic and family violence services, child safety support for victims, the further development of co-responder models between QPS and specialist domestic and family violence services to deal with domestic violence complaints, including in remote and regional communities, and a post-conviction civil supervision and rehabilitation order. There are recommended amendments to Queensland's Criminal Code, Penalties and Sentences Act, Evidence Act and Domestic and Family Violence Protection Act. The Taskforce recommends a review of defences under the Criminal Code, including provocation, self-defence and killing for preservation in an abusive domestic relationship, together with the mandatory life sentence for murder. A review of the scheme under the Dangerous Prisoners Sexual Offences Act 2003 and a consideration of whether it should be extended to dangerous violent offenders is also recommended. Importantly, the Taskforce recommends the appointment of an independent implementation supervisor so that the public will know the progress of the implementation of these proposed reforms. This report has been a mammoth undertaking in a short time frame. I sincerely thank my Taskforce members who have so generously volunteered their time and wisdom while in demanding full-time roles. My small secretariat has been extraordinary in its diligence and commitment. I owe them all an enormous debt of gratitude. So many women thank the Taskforce for allowing them to tell their stories. I thank those women. The wealth of knowledge we gained from hearing their lived experience was at the heart of our recommendations for the Queensland Government on how to best legislate against coercive control and make victims safer and perpetrators more accountable. For these women and girls, being heard and believed is the important first step towards recovery and their journey to justice. Kaunju Kukuyau Girame artist Emma Hollingsworth created the exquisite artwork on the cover of the report. She called it Journey to Justice. For Emma, it represents the complex journey ahead for our community to protect and better the lives of women and girls in a fairer world. The many interconnected circles of loving and supporting communities represent our culturally and gender diverse society. The mountain represents the hurdles to surmount to achieve justice. In the centre is the sun, a symbol of hope. The U-shapes with spears represent men, not as perpetrators but as protectors of women, helping and supporting victims on their journey. Journey lines connect the circle communities and lead to the circle in the top right-hand corner, surrounding a U-shape. This is the woman who has completed her journey to justice, resting in comfort and safety in her own community. Legislators, public servants, friends, families, bystanders, community members, service providers, police, lawyers, judicial officers, together we must listen to and act on the voices this Taskforce has heard Together we can do so much more to make perpetrators accountable and keep women and children safe, including First Nations and culturally and linguistically diverse women, LGBTIQA+ people, elderly women, and those with disability. It starts if together we hear her voice.